Hello everyone, this is CA Rohit Grover. I'm a qualified chartered accountant and a qualified CMA as well. So as you all know that we have already covered up to the disqualifications of director in our previous marathon lecture for the CMA Interlaw. So I welcome you all to the another lecture on the CMA Interlaw, and let's proceed with the next topic without wasting any time. So up to the previous topic, we have already covered what do you mean by director and what are the different types of directors, and we have also covered what are the different categories of the directors are there. We have also discussed in detail about a director called independent director, and we have also covered everything about one director called women director and whole-time director, and different types of directors we have understood. And we have also covered what are the provisions relating to disqualification of directors. Now, in this particular topic, we are going to understand the very important sections, the remaining sections which are very much important from the directors chapter point of view. The first section is when the office of the director shall become vacant. Means what? We are going to basically talk about vacancy of the directors. So when a particular director vacates his place of office, then in that case, what is the provision under section 167 talks about it. Now see, what are the cases under which director will be able to vacate his premises? What are the cases? Case number one, if he incurs any disqualification specified under section 164. So if you all remember, yesterday we have discussed about the disqualifications. Am I correct? So disqualifications may be discussed if he goes insane or insolvent, undischarged insolvent, or call money is not being paid and 6 months are elapsed from that, convicted for an offense of moral turpitude. So if you get disqualified under section 64, then in that case immediately you have to leave a company as a director. Your office will be vacated immediately. Is it clear, everyone? Yes. Point number two, if he absents himself from the what? If he absents himself from all the meetings of the board of directors during the period of 12 months. During the period of how many months, everyone? 12 months with or without seeking a leave of absence of the board. Say for example, for the continuously 12 months, he did not attend any kind of board meeting. So in the last 12 months, if he has not attended any board meeting and he was absent from the board meetings without taking any permission, then in that case, from the next day onwards, he has to vacate his office. Next point, everyone. If he acts in contravention of the provision of section number 184. What do you mean by 184? Say for example, a company entered into a contract with the interested party. A company entered into a contract with the company, and when the company is entering any contract with that company, this particular director is interested party in that contract, but he did not disclose his interest. Are you getting my point? He did not disclose his interest. So when he did not disclose his interest, what will happen in such particular cases? That person will be treated as what? That person will be treated to vacate his office immediately. So remember, when the company is entering into any kind of contract, it is your responsibility to ensure that you should mention your interest in that contract under section 184. But if you do not mention your interest in that contract, in that case you have to vacate your office immediately. What is the fourth case? If he fails to disclose his interest in any contract or agreement in which he is directly or indirectly interested. Same, these both the points, point number 3 and point number 4, are connected with section number 184. If you do violate the section number 184, you are definitely going to vacate your office. But if you do not disclose your interest also in the 184 interested contracts and arrangements and agreements, then in that case also you have to vacate your office immediately. So far we have done the 4 vacations, everyone. If you get disqualified under section 164, you were absent from your board meetings for the last 12 months continuously without taking any permission of absence, and most importantly, you have violated section number 184, and at the same point of time you have violated the not disclose your interest in that particular contract. Next one, if he becomes disqualified by the order of the court or tribunal. If the court or tribunal has disqualified you to be a director, you immediately have to vacate the office. Next one, same point, if you have been convicted for an offense of moral turpitude and you have gone to the imprisonment for not less than 6 months, the office shall be vacated by the director even if he has filed the appeal against the order thereof. So remember one thing, if you have been convicted for an offense of moral turpitude, then in that case you are a director, but you have to vacate your office even though your appeal is going on in the court or tribunal. Are you getting the point? and you must have been convicted for not less than 6 months. Next one, he's removed in the pursuance of the provisions of this act. Suppose you have been removed under the section number 168, then in that case also you have to vacate your office. Or he has been appointed as a director by virtue of his holding of any office or other employment in the holding associate and ceases to hold such office. Say for example, you were having some holdings in the holding company or subsidiary company or any kind of associate company. Due to that reason, they appointed you as a director, but now you have ceased to hold any securities in that holding company, subsidiary or associate company. Due to that reason, you have to vacate your office. So basically, in total, there are 8 types of vacation reasons we have done. Reason number 1, if you are disqualified under section 164, you absent yourself from the board meeting for continuously 12 months without taking a permission. You violated section number 184, you are not disclosing your interest in that. You have been disqualified by the court or tribunal. Then you have been convicted for the moral turpitude for an imprisonment of not less than 6 months. Then you have been removed under section 168, or you have ceased to hold the securities in that particular holding and a particular associate and subsidiary company. And you have 9th point, you have breached your maximum directorships. Remember one thing, you are allowed to be a director only in the maximum 20 companies. The moment you will breach this limit, in that case you will be immediately vacating your office. Now, what is a note? A private company may by its article provide any further grounds. So means these grounds are already applicable to the private company, but if the private company wants, they can add some additional grounds in their article of association for the vacation of director. Next one, where all the directors of the company vacate their office under any of the disqualification, the promoter or in his absence, the central government shall appoint the required number of directors who shall hold the office till the directors are appointed by the company in general meeting. Now, say for example, all the directors of a particular company, A, B, C, D, E, F, suppose 6 directors were there, all the 6 directors have to vacate the office under section 167. Then none of the director is there in the company to manage. Then in that case, central government will step in and central government will appoint the necessary directors in the company. Clear? Next one, if a person functions as a director even when he knows that the office of director held by him has become vacant or account of any disqualification, he shall be punishable with an imprisonment for a term which may extend to 1 year, or with a fine which shall not be less than 1 lakh and maximum 5 lakhs, or both. They are saying that suppose you are already disqualified as a director under section 164, and say for example you are still continue to hold the office as a director, you are already told you have to vacate the office, but you are not vacating the office, you are still continuing as a director even though you are not eligible to, then you will be sent to the jail, which may get extended up to 1 year, or you may end up paying the fine which is minimum 1 lakh, maximum 5 lakh rupees, or sometimes both. So these are the provisions relating to vacation of the director under section 167. Clear everyone? Next one, can a director be removed? What is the question, everyone? Can a director be removed? That is what section number 169. Sorry, I misplaced the section number 168. That is, this is section number 169. That is resignation. 168 is a resignation, maybe. Now, see, section number 169. What is section number 169? Removal of the director. 167 talks about vacation of the director. 169 talks about the removal of the director. Now, remember one thing. Generally, a director has removal only and only by the members by passing an ordinary resolution in the meeting. You can remove a director, only by passing an ordinary resolution. So say for example, if Mr. A is a director, now say for example, if Mr. A is a director and we want to remove this director under section 169, then in that case ordinary resolution in the general meeting is required. Which resolution in the general meeting is required? Ordinary resolution in the general meeting is required. Without passing the ordinary resolution in the general meeting, you are not allowed to remove a director. And one more thing, nominee director, if you remember, nominee director or the director appointed by tribunal, nominee director or a director appointed by tribunal cannot be removed under section 169. It means normal directors you can remove, but the nominee director or the director appointed by the tribunal cannot be removed under section 169. Now see, a company may remove the director by passing an ordinary resolution. Clear? a company cannot remove a director who is appointed by the tribunal, right? Following is the procedure for the removal of director and to appoint another director in the place of removal of director. Now listen to this point very, very carefully. Whenever generally, let me tell you one thing. What is the total procedure? Generally, a director serves for 3 years, right or not? But we want to remove this director before the expiry of the term, before the expiry of term. So say for example, there is one director who is going to be appointed for how many years? 3 years, but we want to remove him before the expiry of the term. Now, before the expiry of the term means what? Say for example, we want to remove him even after completing 2.5 years only. Now, in this case, what we are going to do, first of all, members are going to send special notice to the company. Now, what do you mean by special notice? This is special notice under section 115. The special notice is the notice which is required to be sent by the members to the company holding at least 1% of the voting right or 5 lakhs worth of paid up share capital. And in this notice, what they are telling to the company? In this notice, they are telling to the company that we want to remove a director. Now, obviously, company will receive this notice. Now, what the company will do? Company will conduct a general meeting. In this general meeting, company will pass the OR. What is OR? Ordinary resolution, and or sometimes by the SR, ordinary resolution or special resolution. Now, once the ordinary resolution or special resolution is passed, that Mr. Director stands what? Removed. This is a generalized process for removing the director before the expiry of the term. So let us see the proper legal process how we can remove a director. Now see, first of all, as I already told you, point number 1, a special notice of any resolution shall be sent for a meeting in which the director is to be removed by the company. Next one, on receipt of the notice, the resolution to move a director, the company shall send a copy of it to the director concerned. Obviously, there is one Mr. A who is getting removed. Now, when Mr. A is getting removed, obviously company has to send one notice to Mr. A that we got the special notice from the members, they want to remove you as a director. Okay. Now, the director, whether he is a member or not, is entitled to be heard at the resolution. What do you mean by that? Obviously, in the meeting, when you are going to remove a director, that director will be given an opportunity of being heard. What will be providing him? Opportunity of being heard. What do you mean by opportunity of being heard? That director will be given an opportunity to defend his what? Removal. To defend his removal. What do you mean by to defend his removal? In that case, he will be heard by the company. If the company thinks that yes, he is a genuine person, company may change its decision of not removing him. But yes, if the company thinks that he is not a genuine person, he should be removed, then in that case, he will be removed. But opportunity of being heard is to be given. Next point, director concerned may make his representation in writing to the company. Means what? We are giving the opportunity of being heard. Either we can hear him in the meeting, or we will give him the opportunity to speak about his removal in the meeting, or we can also give him an opportunity to make one letter in which he will tell to the company why he should not be removed. But opportunity of being heard shall be provided. Next one, director may request the company to send his representation to the members. So obviously, that representation which is sent to the company why I should not be removed, director may request the company to send this representation to the members, so that those members who are going to come in that meeting and pass the resolution, they should also know that why that particular director should not be removed. So it is also a part of opportunity of being heard. Am I correct? Now, company, if the time permits, in any notice of the resolution given to the members, state the fact of the representation have been made. So obviously, if the company wants, in the notice only they can attach. And they can tell to the tell to the members that yes, director wants not to get removed. So this is what his defense against his removal. Or send the copy of representation to every member to whom the notice is sent, whether or before the after the receipt or representation of the company. Either the company may disclose that fact in the notice, or company may send the representation copy as a direct attachment with the notice which we are sending to the member. If the copy of representation is not sent due to the insufficient time. Now, let's say, for example, the director sent the representation to the company and the company is unable to send that representation to the member due to the insufficient time, then what the company is going to do? The company is going to allow that director to come into the meeting of the members, and he will be given a little bit of time to read out that letter in front of every member, so that every member can hear him what he wants to say and why he should not get what? Removed. Right, everyone? Next point. The copy of the representation need not be sent out or read out at the meeting if on the application either of the company or any person who claims that aggrieved tribunal is satisfied that the rights conferred by this section are being abused to secure needless publicity for defamatory matters. Now listen, before sending his representation to the member and before giving him the opportunity to attend the meeting to read out the letter in front of the members, we are going to send one copy of this letter to the NCLT. If the National Company Law Tribunal thinks that this person, the director, is trying to take the needless publicity via this opportunity. Say for example, he's saying that I'm the brother of Prime Minister of India, I know President of India, I should not be removed, I'm a big fellow. We gave you the opportunity to defend your removal, but you are trying to take a needless publicity. Or if the tribunal is satisfied that he's trying to do some defamation to the company, he's speaking some bad words about the company, he's bringing down the reputation of the company down, then in that case tribunal may order the company neither to circulate with the notice his representation letter nor allow him to invite in the meeting to speak about it. Is it clear, everyone? Next point. Tribunal may order at company's cost on the application to be paid in whole or part by the director, notwithstanding that he is not a party to it. A vacancy created by the removal of director may be filled up by the appointment of another director in his place at the same meeting where he is removed. For this purpose, special notice to be of the intended appointment has been given. So in the same meeting when this director is getting removed, then in that case we are also going to send, in the same meeting when this director is getting removed, we are also going to appoint another director in his place because there will be a casual vacancy. Next one, the new director so appointed shall hold the office till the date up to which the predecessor director would be held or he has been removed or he had not been removed. Say for example, the original director to whom we are removing, he was liable for the 3 years. Are you getting the point? Say for example, he was liable for how many years? He was liable for 3 years, right or not? Now we already removed him after 2 years. Say for example, we removed him after how many years? 2 years. Now tell me how much term is unexpired, how much term is left unspent? 1 year is left unspent. The new director whom we are appointing in the place of the old director will be able to only serve what? 1 year, only to the extent of the time period which is not served by the old director. Is it clear, everyone? Yes. Next point, he shall not be eligible for any compensation or damage payable for the removal. Obviously you are being removed because of your bad deeds, or you are being removed because of your bad behavior, or you have been removed because of your fraudulent nature. Obviously at the time of removal, company will not give you any kind of compensation or any kind of money to you. You will be going empty handed from the company. This is how the director gets removed under section 169. I hope you all understood the vacation as well as the removal of the director, right? Write a short note on the overall remuneration payable by the company, remuneration payable to the managing director or whole-time director, and remuneration payable to the directors. Now, I would like to tell you that say for example, when we talk about remuneration, I would like to tell you one very simple chart which you all have to understand, right or not? Which you all have to understand. I would like to tell you one very simple chart. Now see, when we pay the remuneration, there will be two categories of paying the remuneration. When the company is in profit, how much remuneration we can pay, and when the company is not in profit, how much remuneration we can pay. Again repeating, when the company is in profit, how much remuneration we can pay, and when the company is not in profit, how much remuneration we can pay. Is it clear, everyone? So this is what we have to understand about the remuneration. So let me make you understand one very simple clear chart by which you all will be able to understand this whole concept. Now see, let's say for example, we are talking about managerial remuneration. What is the name of the topic? Managerial remuneration. Now when we talk about the managerial remuneration, let us divide it into two parts. When company is in profits, on the other side, when company is in losses or inadequate profits. Which profits, everyone? Inadequate profits, or you can say that insufficient profits. So we will come to the right side later on. First, let us understand when the company is in profits. Now listen to this point, everyone carefully. When the company is in profits, there are total 3 different types of remuneration what the company can pay, which can be 3% of net profits, which can be 6% of net profits. Remember, we are paying the here remuneration on the basis of profits, which can be 11% of net profits. This chart you will never ever forget. I can guarantee you this chart will get permanent in your head. So 3%, 6%, 11%. Maximum is always 11%. What is the maximum a company can pay? 11% of the net profits company can pay the maximum. But if the company wants to pay more than 11%, then central government prior approval is required. Whose prior approval required? Central government prior approval is required. Is it crystal clear to all of you? Yes. So 3% of the net profits, 6% of the net profits, 11% of the net profits. Is it clear, everyone? Yes, sir. We are clear. Now listen to this point very, very carefully, which I'm going to tell you now. Now, when 3% of the net profits, suppose there is a company with only directors. There is a company in which only directors are there, no KMPs are there, no managing director, no whole-time director, no CEO, no CFO. So company with only directors but no KMP. It means this 3% is going to directors. But remember one thing, this 3% of the net profits will go to the directors only when company is only running with the directors without any KMP, without any MD, without any whole-time director, without any CEO, without any CFO. Is it clear to all of you? Yes. 6%. When the company can pay the 6%, suppose the company is with directors, company is running with directors plus 1 KMP. What is the difference in the previous case? No KMP, but here 1 KMP means what? Either one MD is there or one whole-time director is there, or you can say or CEO, CFO, all those people are there. Then in that case, what will happen? 1% only will be paid to the directors. How much will be paid to the directors? 1% will be paid to the directors, and remaining 5% out of 6%, 1% will be paid to the director, 5% will be paid to that KMP, 5% will be paid to that MD or whole-time director. Did you all understand? So company can pay 3% when there are only directors but no KMP. But company can pay 6% when there is 1 KMP and only directors, 1% to the directors, 5% to the KMPs. Is it crystal clear to all of you? Yes. When the company can pay the 11 directors, when the company is running with the directors, plus 2 or more KMPs. What am I? 2 or more KMPs. In this case, 1% again will be paid to the directors and remaining 10% will be paid to the KMPs, because we have 2 or more. So now 2 or more KMPs will get 10% and 1% only to the director. It means if there are no KMPs, directors will get 3%. But if there are KMPs, directors will get only 1%. It means out of 6%, 1% to the directors, 5% to the KMPs, and out of 11%, 1% to the directors and 5%, 10% to the KMPs. This is what happens when the company pays the managerial remuneration out of its profits. And remember, maximum how much, everyone? Maximum 11% of net profits. Maximum 11% of net profits. But beyond that, if you want to pay, you need to take a prior approval of central government. Prior approval of central government is required. So this is what do you mean by managerial remuneration, section number 196 and 197. Now see, let's have a quick look at this. Section number 197 provides that the total managerial remuneration paid by the public company to its director, including MD, whole-time director, shall not be exceeding 11%. I already told you, MD is also there, whole-time director is there. It means, is it a case of can I say that it is a case of directors plus 2 or more KMPs? Yes or no? Yes. So how much I told you just now in the chart? 11%. Company's general meeting may, with the approval of the central government, authorize a payment or remuneration exceeding 11%. So if you want to give more than 11%, I already told you whose prior approval required. Central government prior approval is required. If any director draws or receive directly or indirectly by the way of remuneration in excess of the limit prescribed or without the proper sanction of central government, he shall refund. So obviously, if you are getting more than 1%, more than 3%, more than 6%, more than 11% without central government approval, more than 11%, then in that case, what is the excess remuneration you have received? You have to refund it back to the company. Until such refund, it will be treated as you are holding that money in the trust of the company. Did you get the point? The excess remuneration paid to you will be refunded back to the company. Now, remuneration to WTD or MD. I already told you, if it is one MD or one WTD, then 5% of net profits will be paid to you. But if it is 2 or more KMPs, key managerial person, that is 2 or more KMPs are there, then in that case it will be 10% of net profits, because 1% out of 11% will go to the directors, to the KMPs, to the MDs, and to the WTDs. It will be 10% of the net profits. Now you can see that second proviso provides the remuneration payable to one director or one whole-time director. That is what I wrote. One MD or one TD is 5%. You can see that shall not be exceeding 5%. If there are more than one whole-time director, then the remuneration shall not exceed 10%. I told you 2 or more KMPs, it will be 10% of the net profits. Remuneration payable to directors, I already told you, only directors in the company, then in that case it will be 3% of the net profits. But directors with KMPs in the company, it will be maximum 1% of net profits. So you can see that in the remuneration payable to the directors who are neither the managing nor the whole time shall not exceed 1% of the net profits. It means if there is a MD or WTD, then the directors will only get 1%. But if there is other cases, then it shall not exceed 3%. This is what I already told you in the chart. So make sure that chart should be there inside your head. Remuneration when there is no profit. Remember one thing, when there is no profit. So let's go to the chart. When the remuneration is being paid when there is no profit, then it will be paid on the basis of effective capital. On the basis of which, everyone? Effective capital. So there's one particular chart of the effective capital. Say for example, negative effective capital to 5 crores. Like that one chart is there. We can pay 60 lakhs, then 84 lakhs, then 120 lakhs, then all these different types of provisions are there, right? So when the company is not having adequate profits or company is suffering the losses, then in that case we pay the managerial remuneration not on the basis of profits, but we pay it on the basis of effective capital. Now see this, what they are saying. Provide that if any financially a company has no profits, and adequate company shall not pay to its director, including managing director, by the way of remuneration, exclusive of any sum fee. Remuneration may be payable in such situation in accordance with provision of Schedule 5. So Schedule 5 says that it shall be paid according to that thing. It shall be paid according to the effective capital. Recovery of the remuneration, I already told you, if you have got any extra remuneration, it is your responsibility to return it back to the company. Periodicity of the payment provides that director may be paid remuneration either by the way of monthly payment or specified percentage of net profit, or the partly by the way of one or partly by the other. So monthly payment will be there, or at a specified percentage of net profits of the company, or partly by one way or partly by the another way. So that is all dependent upon the case to case basis. That is purely a company's right? Which part does not form the remuneration? Now remember one thing, when we talk about the directors, everyone, when we talk about the directors, they do get directors and KMPs get what? They get managerial remuneration, plus they also get the which fees? Sitting fees. Now what do you mean by sitting fees? Sitting fees is a fees which you need to attend, which you get for attending the board meetings. So if you attend the board meetings, then in that case you need to get the which fees? Sitting fees. But let me tell you one thing, sitting fees is not a part of managerial remuneration. So sitting fees never becomes a part of managerial remuneration. Now see, A director may receive a fees for attending the meetings on the board or committee meetings thereof for other purpose whatsoever as may be decided by the board. Such field shall not exceed 1 lakh per meeting for the board or committee itself. Means what? Maximum, you can say that maximum up to rupees 1 lakh, up to rupees 1 lakh per board meeting or per committee meeting. Is it clear, everyone? Up to rupees 1 lakh per board meeting and per committee meeting. Next one. Independent directors and women directors may receive the fees not less than the fees payable to the other directors. So they are saying that if you're an independent director or a women director, your sitting fees is also going to be same like the other people, right? Or not. Professional fees. Any remuneration for the services rendered by such director in the capacity shall not be included in the service regarded as professional nature. Say for example, I am a chartered accountant, I am also a director. So as a chartered accountant, if I'm paying my professional services, if I'm giving my professional services, that fees which I'm getting as a professional fees is not going to be the part of my managerial remuneration. So if I'm working as a director, then it will be treated as a managerial remuneration. But if I'm giving my chartered accountancy services or company secretary services or cost and management accountant services, that fees which I'm getting for my professional services are not going to be the part of this particular managerial remuneration. Next one, insurance premium. Section 197 subsection 13 provides that where the insurance is taken by the company on the behalf of its MD, whole-time director, indemnifying any of them against the liability in respect of any negligence, default, misfeasance, breach of duty or breach of trust for which they may be guilty in relation to company. The premium paid on such insurance shall not be a part of their remuneration. Let's say for example, in case company takes the insurance, am I correct? No, company takes the insurance, and in case they are being guilty, in case they may be proved guilty for any kind of fraud and or whatever the premium company pays for that insurance, that is not going to be the part of their managerial remuneration. Are you getting the word? But if such person is proved guilty, if such person is definitely proved guilty, the premium paid on such insurance shall be treated as a part of remuneration. If they have, till the time they have not been proved guilty, till that time it is not going to be the part of the managerial remuneration. But once they prove guilty, the insurance premium paid by the company will be the part of their managerial remuneration. Clear, everyone? Now, what is the next topic? What are the duties of the director? As I already told you, directors basically do what? Directors basically does various kind of duties in the organization, like managing the day-to-day affairs, allotment of security. So many functions directors play in the organization, right or not? So basically, what are the major duties of the directors? The first major duty of the director under section 166 is director of the company shall act in accordance with the articles of the company. So directors, rules and regulations, their power, duties, rights, etc., everything is written in article of association. Whatever the AOA is saying, every director has to act accordingly. Is it clear? Directors of the company shall act in a which faith? Good faith. Obviously, being a director, we are giving you the responsibility to manage the company. So make sure that you're managing the company in the best interest of the shareholders, best interest of the company, best interest of the environment, and best interest of the employees. So as a director, we expect from you that you run the company in a good faith, right? Directors of the company shall exercise his duty with the due and reasonable care, skill and diligence, and shall exercise independent judgment. So we expect a director to be very reasonable, to be very careful, to be very diligent, to be very skillful, and to be very good independent judgment he should have when he is discharging his duty, right? Next point, a director shall not involve in a situation which may have a direct or indirect interest that conflicts. So what they are saying that if you think that there is one particular situation came in which you will be no longer be independent, you may become partial or you may become biased. In such kind of situation, it's better to avoid that situation as a director. Don't get involved into that kind of situation which are telling you to compromise your independent judgment. Next one, director of the company shall not achieve or attempt to achieve any undue gain or advantage. Obviously, as a director, you get a very superior position in the company. So people, you get a very good rank in the company. So people expect that as a director, you should not take the undue advantage of your position. You should not abuse your power. You should not be found guilty of any kind of fraud or undue gain or undue advantage. Clear? Next one, director of the company shall not assign his office and any assignments shall made so be treated as void. See, as a director, we want you to run the company. You are not allowed as a director to give your powers to somebody or assign your duty to somebody. If you will assign your duty to somebody, we do not expect that good quality from that person. Therefore, you are not allowed to do any assignment. If you do any assignment as a director, that will be treated as null and void. And if you do not do your duties as per section number 166, we are going to punish you. What is a punishment? A fine which is not less than 1 lakh, which may get extended up to 5 lakh rupees. Is it clear, everyone? This is what brings an end to your section number 166. Now, what are the powers of the board of directors? Board of directors have lots and lots of powers. They take the very, I think in the management and administration rules 2014, you'll find out that board powers are given under section number 179 subsection 3. There are lots and lots of powers which have been given to the board of directors, like allotment of securities only board can do, forfeiture only board can do, investment decisions board can do, giving the loan only board can do, or what to do in the ordinary course of business board can do, buyback of securities up to 10% board can do. There are lots and lots of powers given to the board of directors. Let's understand one by one. To make the calls on the shareholders, means who will make the calls on the shares? Like you all know that application money, allotment money and call money is there. Who makes the call on the shareholders? Board of directors. To authorize the buyback of securities up to the 10% of the total paid up share capital plus free reserve plus security premium, whatever the buyback you want to do, up to 10%, who has to authorize that? Board of directors. To issue the securities including debentures in India or outside India, whenever any issue of securities, say for example shares or debentures, all that power is also being given to whom? Board of directors. To borrow the monies, it means from whom to take the loan, how much to take and when to take, all that also will be decided by the board of directors. To invest in the funds of the company, where to do the investment, where that money should be invested, that also will be taken care of by whom? Directors of the company. To grant or give, guarantee or provide security in respect of loans. So to grant the loans, to give the guarantee or to provide the securities, that decision also will be taken by the board of directors. To approve the financial statement, you know that financial statements are required to be audited, but before it is required to be audited, it is required to be approved by the board of directors, right? To diversify the business of the company, in which business we should enter, which business should be closed, business should be expanded, all these decisions also will be taken by the board of directors. To approve amalgamation and merger and reconstruction, when the amalgamation takes place and when any mergers takes place or when any reconstruction decision takes place, when to do, what to do, how to do, all these decisions will be approved by the board of directors. And board of directors also will be taking the decision whether substantial risks are involved or substantial stake is involved. Say for example, you are doing the takeover of any company, you are absorbing any company, you are buying any company, all those decisions also will be taken by the board of directors. To make the political contribution, if you want to make any contribution to the political party, that decision also will be taken by the board of directors. To appoint or remove KMPs, yes, very important point. Generally, we think that KMPs are more powerful than the board of directors. And let me tell you, yes, KMPs are very much powerful than the board of directors. Remember one thing, KMPs ka approval, reappointment, removal, everything will be done by the board of directors. Even though they are more powerful than the board of directors, but board of directors have the right to approve them, to appoint them, to reappoint them. Clear? To appoint internal auditors and secretarial auditors means what? Who should be the internal auditor? Who should be the secretarial auditor? All that will be. And one more thing, you can write cost auditor also. Right or not? Cost auditor under section 148. That also will be appointed by the board of directors only. The board may by resolution passed at meeting delegate to committee of directors. If the board of directors want to delegate their powers, they also have a power to delegate this to the committee of directors. Is it clear, everyone? So explain briefly the restrictions on the powers of the board. Now, this is a very, very important topic. See, just now we have done section number 179 subsection 3, where we talked about the powers of the board. But boards are not allowed the absolute powers. There are some areas, I'm not saying they are prohibited. Look at the word, what is written first of all. The word used is restriction, not prohibition. Restriction means subject to some conditions, they can exercise these powers. But generally, they are not allowed to exercise these powers. Generally not allowed, but some restrictions are there. What do you mean by some restrictions? See, they have to pass special resolution. They have to take the permission of the shareholders by passing a which resolution? special resolution. Are you getting the point? It means board of directors are only taking the decision. They will take the decision, but to be approved by the shareholders by passing a which resolution? Special resolution. It means we need board resolution plus we need which resolution? Special resolution. Is it clear, everyone? Yes. So what are those kind of powers where there are some restrictions are there? To sell or lease or otherwise dispose of whole or substantially the whole of the undertaking, or where the company owns more than one undertaking, the whole or substantially the whole of any such undertaking. Say for example, company is taking the decision to sell some of the part of its business or total business. This decision board of directors alone cannot take. Now try to understand the logic. Board of directors are the one who are managing the company, but who are the owners of the company? Shareholders are the owners of the company. So until unless shareholders do not approve it by passing a special resolution, board of directors are allowed or not allowed? Not allowed to take this thing. So board resolution is also required plus special resolution is also required. So you can write here as BR plus SR. Is it clear, everyone? Yes. Next point. To invest otherwise in the trust securities, the amount of the compensation received by it as a result of merger of amalgamation. If you want to invest your money in the trust securities which you received as a result of any amalgamation or merger, that also board of directors alone cannot take. They have to take a special resolution of the shareholders also. To borrow the money when now listen, there already existing borrowings are there. And now let me give you one example for this point. Now see, let's say for example of this point. Say for example, there is one company called ABC Limited, right? Now this ABC Limited paid up share capital is 100 crores. Free reserves are 40 crores. Securities premium is 60 crores. So in total 200 crores, right? Now this company already has taken a loan from the SBI of 160 crores. Listen, this company is thinking of taking a loan from ICICI Bank. This company is thinking of taking a loan from which bank? ICICI Bank. They want to take a loan. How much? They are thinking of taking a loan of another 60 crores. This is already existing loan. And this is proposed loan. This is a which loan? Proposed loan. That is existing loan. And this is a proposed loan. Now they want to take this loan. Now tell me, already existing is 160 plus 60, it will be 220 crores. Are you getting the point? Now tell me, is this 220 crores more than 200? It means if your existing borrowings plus proposed borrowings are greater than your total paid up share capital plus free reserves plus securities premium, in such cases, what is going to happen? You need to pass a board resolution plus special resolution. This is what is written here. Read everyone very clearly. To borrow the money where the money to be borrowed means proposed borrowing, together with the money already borrowed means present borrowings, exceed aggregate of its total paid up share capital plus free reserve apart from the temporary loans obtained from the company's banker in the ordinary course of business. Next one. To remit or give time for the repayment of any debt due from the debt director. Say for example, there is one director who has taken a loan from the company. Now, this director has been told to repay the loan within 5 years. But after 5 years, this director comes and says that, sir, I need some extension of 1 year. Now tell me, can the board of directors alone can give the extension of 1 year to this director? Answer is no. Board of directors alone cannot give this extension of 1 year to that director. They can approve it, but finally it will be approved by the shareholders by passing a special resolution. So here also you need BR plus SR, and here also you need BR plus SR. Is it clear, everyone? Yes or no? So these are those kind of powers. Some restrictions are there. What do you mean by some restrictions? You need to pass a board resolution, but later on you have to get it approved by the shareholders by passing a special resolution. Is it clear to all of you? Yes, it is clear. Now I think we are moving towards the winding up of this chapter. We are left with hardly 2-3 small sections. Section number 182. What is 182? Contribution to the charitable funds and political parties. 182 is already talks about the political parties. Now see, say for example, so this is not relating to political parties. This is relating to charitable funds. The power of making the contribution to bona fide charitable and other fund is available to the board of directors subject to the certain limit. Further, the permission of the company in the general meeting is required if such contribution exceeds 5% of its average profit of last 3 financial years. Now, let us see. Suppose in the 2021 financial year, it is 40 crores profit, or 1920 financial year, it is 20 crores profit. You can say 21-22 financial year, it is 60 crores profit. Am I correct? Now, what is the total of that? The total of that is 120 crores, and let's do the average of this thing, that is called 40 crores. Am I correct? Now, say for example, we will calculate 5% of this. We will calculate 5% of 40 crores. So 5% of 40 crores, if I'm not wrong, it is coming to 2 crores. Am I correct? 5% of the 40 crores comes to 2 crores. Am I correct, everyone? Yes. Now, there is one company who wants to do the charity, right? Now, this company wants to do the charity. If they want to do the charity of 1 crore only, is it less than 5% of the average of the last 3 years profits? What is the average of the last 3 years profit? 120 crores divided by 3, 40 crores. On that 5%, is the 1 crore less than 2 crores? Yes. Then board of directors can do. But if this charity they want to do is 2.5 crores, is this 2.5 crores more than 2 crores? That is 5% of the average of last 3 years profit? Yes. Then the board resolution plus special resolution, both are required. Is it clear, everyone? Yes or no? Did you all understand? Yes or no? Did you understand about this one? So if you're doing up to 5% of the average of last 3 years profit, BR is enough. But if you are going beyond that, then BR plus SR by the shareholder is enough. That is what is written under point number 1 and point number 2. Clear, everyone? Yes. This is called contribution to the charitable funds or other funds like that, section number 181. Now, what is 182, everyone? Charitable to the contribution to the political parties. Now, they are saying that according to 182 of the Companies Act, company other than the government company which has been in existence for less than 3 financial years may contribute any amount directly to any political party. It means if you are a government company, now listen to this, if you are a government company, if you are a which company? Government company, you can directly make a political contribution. There is no restriction on you. There is no prohibition on you as a which company? Government company. But if you are other than government company, if you are other than government company, central government or state government company, then in that case, you should be in existence for minimum 3 years. It means 3 years must have elapsed from your date of incorporation. Then you will be allowed to do the political contribution. So again, repeating, if you're a government company, no restriction. If you're a government company, no restriction. But if you are other than government company, you should be in existence for minimum 3 years if you want to contribute anything to the political party. Now the question arises, sir, who can contribute? Again, what is written? Board of directors can authorize. Who can authorize? Board of directors can authorize, and it should be other than cash. It should be other than cash. Board of directors can authorize. It should be other than cash. Point number 2. Point number 3. If the expenditure incurred on the advertisement in the publication, souvenir, brochure, tract, pamphlet or like is deemed as a political contribution, if such publication is by on the behalf of political party, if not, then of the advantage to such political party for a particular purpose. It means where you can spend that money. You can spend that money on the brochure, souvenir, pamphlets, tracts. You can do it any kind of contribution which is helping that political party. Company is required to disclose in its pre-annual account any amount contributed by it with a political party during the financial year, and in particular the total amount contributed and the name of the party to whom it is contributed. Means what? They are saying that you have to show that particular contribution which you made to the political party in your P&L statement, plus you have to tell to which political party you have made the name of the political party to whom you have made the contribution, as well as to whom you have made the contribution. Is it clear, everyone? So remember, if you're a government company, there is no prohibition in making the political party contribution. But if you're other than a government company, then you need to be in existence for 3 years, everyone. Is it crystal clear? Yes. But if you are doing any contravention of section number 182, then in that case, the contribution in contravention that shall be punishable with an amount which is 5 times of the amount so contributed, and every officer in default shall be punishable for imprisonment up to 6 months, and the fine which is 5 times of the amount so contributed. So what is the penalty on the company? On the company, it is 5 times of the contribution made. If you're violating section number 182, you will be ending up paying a fine of 5 times of the contribution paid. Officer in default, the one people who are involved in this kind of default, they will also be 5 times the contribution paid, or imprisonment. I think it's not or. Whoa, it is not or. It is and imprisonment, everyone. It is and. What do you mean by and imprisonment? It means they will end up paying the fine, that is 5 times of contribution made. At the same point of time, imprisonment up to 6 months. Imprisonment up to 6 months. It means they will be going to the jail up to 6 months, as well as this one also. Now, section number 183. The 181 was talking about the charity, which should not be more than average of the last 3 years, 5% of average of last 3 years profit, and political contribution. Make sure that if you're a government company, no problem. If you're a non-government company, it should be in existence for 3 years. Now, you want to make a contribution to the National Defense Fund. You know that we love our Indian Army, we love our Navy Army, we love our Air Force. So, if you are making any contribution to the National Defense Fund, there is no restriction. Any amount you can contribute. What is written? The board is authorized to contribute such amount as it thinks fit. Means what? Whatever the contribution you want to make, you can make. No restriction, no limit. To any other fund approved by the central government for the purpose of national defense, the company is required to disclose it in P&L account to whom the amount has been made during the financial year. This is what you have to understand about 181. The 171 was the power of the board, 180 was the restriction on the power of the board, 181 is to the charitable, 182 is to the political party, and 183 was to the National Defense Fund. Now, let us wind up this chapter with our last topic, that is called 168, that is called resignation. Now, there is one director who want to resign. Can he resign? Yes. So, what is the difference between removal and resignation, everyone? Removal means company is removing you. Removal means company is removing you. Resignation means you are voluntarily giving a resignation. You are giving a resignation voluntarily. Right or not? Now see, section number 167 talks about vacation. 169 talks about removal, and 168 talks about the resignation. See, last topic, everyone. A director may resign from his office by giving a notice in writing to the company. Obviously, you are leaving the office, so you have to give a written notice to the company that I am resigning. Now, question is, in which form you have to give this notice? He shall, within the 30 days from the date of resignation, forward to ROC a copy of his resignation along with the reasons of resignation in form number DIR 11 along with the fees. So, director has two responsibilities. One, he is giving the notice to the company that I am resigning. Second is, in DIR 11 form number, he has to intimate to the ROC, sir, I am resigning, along with the reasons of resignation within 30 days from the date he has resigned. So suppose he has resigned today. That is 9th June 2022. So within 30 days from the day, he should intimate to the ROC the reasons of his resignation in form number DIR 11. Crystal clear? If you are a foreign director, may authorize in writing a practicing chartered accountant or cost accountant in practice or CS in practice or other resident director to sign the form number DIR 11 and file the same on his behalf, intimating the reasons of his resignation. Suppose you are a foreign director, you are staying in United States. So you cannot come to India only to file the form number DIR 11 to the ROC. Obviously, only for one form, you will not land to India. So he may authorize a practicing CA or a practicing CMA or a practicing CS to fill that DIR 11 form on their behalf and sign it on their behalf within 30 days of his resignation. Now they will intimate that to the ROC. So director intimating to the ROC, form number DIR 11. When the company is intimating the same thing to the ROC, DIR 12. Now see, the board shall on the receipt of notice take a notice of the same. Board will record that yes, one of the director resigned, and the company shall intimate the same to the ROC. Who shall intimate? Company will intimate same to the ROC in DIR 11 within 1 month from the date of receipt. So when the director is intimating, this is form number DIR 11. And when the company is intimating, it is form number DIR 12. Director is intimating within 30 days of his resignation. Company is intimating within 1 month from the receipt of the notice of the resignation from the director. Next one. The said information is to be posted on the website of the company. The company has to post that our director has left the company, resigned the company on its website, so that everyone will come to know that this director is no longer associated with this company. The fact of the resignation should be laid down in the report of directors immediately following the general meeting by the company. So in the coming shareholders meeting, you have to put that one of our director has already resigned. Resignation of the director shall take effect from the date on which the notice is received by the company or the date which any specified by the director, whichever is later. Say for example, director has given the resignation today, but he is saying that my resignation should be accepted from 7th September. So 7th September onwards only he will be assumed to be resigned. But if he has not specified any kind of date of his resignation, then he will be assumed to have resigned from the date on which the notice has been received by the company. The director who has resigned shall be eligible even after his resignation for the offences which occurred during his tenure. Right or not? Even after resignation, if you were involved in any kind of offences during your tenure, even though you have resigned it, you will still be liable for all those offences even though you have resigned the company. It means if you were during the tenure were involved in some of the offenses, you are not completely free from those offenses. You are still liable. And point number 10, everyone, where all the directors of the company may resign. You all know when all the directors of the company may resign. Same point we have done in 167 vacation also. When all the directors are vacated or all the directors of the company have resigned at one point of time, central government interferes, and in that case, central government will let you know how to. At the central government will appoint the remaining directors to run the management. That our all the major topics relating to directors chapter is over. So there are some preliminary topics, some patch up work is left, like what do you mean by register of debentures, KMPs and all those things. They are giving in the self study material. Clear everyone? So I hope this lecture also was useful to you. Thank you so much for lending your patient ears patient ears again everyone. So I hope this lecture also was proved to be beneficial to you. Thank you so much for lending it, and I will take your leave now. I'll see you guys in the next lecture. Bye bye everyone. Take care. All the best everyone.